you're all well today. Today, we have today's webinar on navigating fire and rehire, so the best practices for small businesses. Now, if you've been here before, you'll know the rules. If not, these are the rules. Your microphone is automatically muted, so don't worry. If you do need to cough or sneeze, you're not going to interject anything that we're doing today whatsoever. I've also attached a handout to today's session as well, so download that when you can. There's a black and white copy and a colour copy as well that you keep on your desktop. You can print off the black and white copy if need to be and take notes if you're a bit like me. Also, you can send us your questions using that speech bubble and the question mark. So anytime you have a question, just fire it straight in and hopefully we'll be able to get you an answer. Anything that isn't answered during the allotted time today, we will pick up directly and be in touch with you afterwards. So have no fear, no question is left unanswered. Now, I'm joined today by Advisor Plus HR Technical Consultant Emily Bennett and Senior HR Advisor Katie Reese, and they're going to share their expertise on this topic and get into the practicalities on what you can be doing to prevent any risks. So if you'd like to introduce yourself, guys.
I'll start. So hi, my name is Emily. I've worked in HR for over 10 years now. I've worked with a number of different kind of business types. I've worked in the health sector, telecommunications, utilities and builders merchants. I have a level 7 CIPD and a master's degree in HR management. And my role at Advisor Plus involves supporting the advisory team with any complex, any high risk cases. And also I focus on upskilling and training the teams as well. But I will hand over to my colleague Katie so that she can introduce herself.
Hi, good morning. I'm Katie. I've worked in HR and employment law now for 25 years. I've been an advisor with Advisor Plus for 3 years now, supporting customers with their ER issues and coaching managers. Before this, I've worked in private practice, in-house and for consultancies, providing advice, consultancy services as a litigator and representing clients in mediations, arbitrations and early conciliation in the Employment Tribunal and Appeal Tribunal. I've also delivered mock training, mock tribunals and legal updates.
Superb, superb. So today we'll be covering the challenges that come with the practice of firing and rehiring and why it's important to get the process right from the start. Now, we'll go over what fire and rehire is and when it should be used, the difficulties that need to be taken into consideration when using the process and addressing common challenges and avoiding legal risks, the ethical challenges around the fire and rehire practice and the impact that this can have, upcoming legislation that could impact the practice, 0-hour contracts alongside their benefits and complications, and we'll make sure that at the end of the webinar you can access the slides that we've used throughout today's session. We share the webinar recording with you as well, so you can watch it back on demand, and we share any links to the portal of the policies and the areas you need to pay particular attention to. Again, near the end of this session, I'll be sharing more on how to access that kind of information and those assets. But first, Emily, let's get started. What is the fire and rehire process?
So you might hear the process referred to as either fire and rehire, or you might hear it referred to as dismissal and re-engagement, but it's the same. So this process comes up where a business wants to change terms within a contract, but you have an employee or employees who are refusing to agree to those changes. So realistically, you want to use fire and rehire as an absolute last resort, given how serious it is to dismiss someone. And the process of fire and rehire is generally not looked at in a kind light. That's coming out in some upcoming employment law, which we're going to recap in a little bit as well. What the business could do in this situation where they have someone who is refusing to agree to a new term is to dismiss the employee from their current contract and then offer to rehire them straight away on the new contract, on the new terms. It could be because the business is trying to change terms such as maybe working hours or working locations, or maybe to change tasks and responsibilities, and the employee is refusing to accept those new terms. Before looking to fire and rehire, a business should really have made all attempts to resolve the matter in another way. Generally, what we'd see is this being done via a consultation process where the business explains the need for making whatever contractual change it is. So what are they trying to implement and why are they trying to implement it, and why is it so business critical that they need to change the contracts? And this consultation process should be done regardless of whether the business believe the employee will accept the change or whether they won't accept the change.
This is where things can become complicated. You're right, Emily. I think before delving into the world of fire and rehire, it's important to review the variation of contract as a process, as that's really where it all begins. So when looking to implement a change to a contract, ACAS guidance states that you should consider what issue you're trying to solve and what other ways it can be solved in, rather than changing the employee's contracts. They note that changing a contract can cause tension in a business, so not managing the process well can result in damaging working relations between the employer and the employee, legal claims, brand damage, strikes, or increased absences, or instances of employees working to rule, meaning they only do the bare minimum of what they're employed to do and nothing else. So that's why it's so important to be certain that you definitely need to implement a contract change before you start announcing that that's the plan. There is also the Dismissal and Re-engagement Code of Practice, which can be found on the gov.uk website, which is part of the Trade Union and Labour Relations Act of 1992. That does need to be followed. So again, try and protect yourself from legal claims this way.
It's good to know that there is actual legal guidance around this process as well. And what does that code of practice say?
So the code of practice sets out that it's for the employer to take all reasonable steps to explore alternatives to fire and rehire, and also to engage in meaningful consultation with the employees and their representatives if that's appropriate. So the code of practice confirms what information should be shared with employees as part of the process, including what the proposed changes are, which employees will be affected, what are the reasons for those changes, when, so what are the anticipated timings of those changes coming in, and then any other options that are being considered as well. What the code does note is that the more information the employer can provide, the better, because this will allow for a more transparent and a more meaningful consultation process. Following the business providing those initial facts to employees, the business would then need to step into that meaningful consultation that I keep referring to. And the key word here really is meaningful. So to read a direct quote from the code, consultation is not a question of only following the right procedure. To enable meaningful consultation, parties should engage with each other openly and in good faith. They should genuinely consider the points that are put forward. So what it's trying to say there is that whilst the employer might have explored other options themselves, and therefore they're already confident that varying the contract and then having to consider fire and rehire if employees don't agree, they might have already decided that's the right course of action. But it could be that an employee comes up with an idea that hasn't yet been considered. And it is important for employees to demonstrate that they're taking all ideas on board, and that they have genuinely thought those ideas through, and that they've responded to those ideas as well. The code also states that this consultation should continue for as long as reasonably possible in the hopes of reaching an agreed outcome rather than having to take another option such as fire and rehire. If an agreement can be reached, then what would happen is the new contract can be drawn up and then it would be signed as appropriate. It is also worth noting that if the employer plans to dismiss and rehire 20 or more employees, then they do need to collectively consult on the dismissals as well.
So now we're back to where the employees do not agree to the changes despite consultation, and that is where the fire and rehire process would commence. Is that right?
Yes, that's right. And again, we want this to be the absolute last resort. So to repeat Emily, it's really important to make sure that all the other options and ideas have been explored. So if then the employer is adamant that the changes need to occur, they should let the employee know as part of the ongoing consultation process that they will need to consider dismissal and re-engagement if those terms can't be agreed. It's key to think about when the best time is to raise this, as it can cause difficulties in the ongoing consultation if the employee feels that they are maybe being threatened with dismissal. And to be clear, the idea of dismissal and re-engagement shouldn't be used as a threat to try and force through a negotiation, and it shouldn't be mentioned if the business actually has no intention of dismissing anybody, just to put undue pressure on an employee to agree to the changes. If the business is absolutely refusing, if the employee is saying to the business that they're absolutely refusing to agree to those changes, it is at this point that the business should re-examine what it's proposed, whether they still do need to implement those changes. And at this point, the business should consider the feedback it's received via the consultation process. And if it's still confident in their case, it's at this point that they may then move into the dismissal and re-engagement section of the process.
Yeah, and then this is where normal practice around dismissals will come in as well. So for that dismissal to be fair, it needs to follow a fair procedure, and the business needs to demonstrate that they have acted reasonably in deciding that dismissal is a fair outcome. The dismissal itself should take place as part of a formal meeting. There should be an invite letter, there should be notice to that meeting, and that should be given alongside the right to be accompanied by either a colleague or a trade union representative. Following the meeting, the outcome should be confirmed in writing, and the employee should also be given the right to appeal as well. Generally, what would happen at this point is that when the business sends out the outcome letter confirming the dismissal, they will also send out a copy of that new contract with those new terms and conditions alongside the outcome letter. And they will also confirm that the business is still happy to rehire the employee on the new terms as long as they accept and sign that new contract. And if that is what's going to happen, we want to see that re-engagement happening as soon as possible.
Oh, brilliant. Thank you for explaining the process and obviously when it might be used. And it sounds like it can be quite a difficult undertaking. So what are the key risks using fire and rehire as a way to force through a contract change?
It's definitely a really difficult one to get right in terms of balancing what your business needs are, but also trying to keep the employees on side. I think the most obvious risk from this one is the people fallout. If you take it for you, for example, if you imagine you've signed a contract with a business, you consider this contract to be legally binding, and then your employer suddenly turns around and says that they're going to change it to something else, something that you consider to be less favourable. Oh, and by the way, if you refuse these changes, you could lose your job. You can understand how employees on the other side of that process could feel very aggrieved by the whole thing. And this is why it's so key for businesses to explain to the employees impacted why it is so business critical that the changes are put in place. Hopefully by explaining this, it will help the employees understand where the business is coming from, even if they're still not happy about the changes. It's really important to deal with this situation with sensitivity and understanding, and to consider what you can do to make these changes more agreeable as well. And because ultimately what you want is for the employees to agree to them rather than having to go through the fire and rehire process. ACAS does provide some great examples as to how to make it a bit more palatable. So things such as making the changes gradually rather than introducing them all at once. Starting the change on a temporary basis to see how it works in practice before you make it actually contractual, and then ensuring that all colleagues feel fairly impacted as well. So for example, are we just asking our junior colleagues to change their contracts, but senior management don't have to, and then it kind of feels a bit like favoritism, or actually is everyone being equally impacted by this change who needs to be? Another risk would include claims at employment tribunal. So a colleague might seek to claim a breach of contract if you change their contract without their agreement. They might also look to resign and then claim constructive dismissal if they felt that they were forced to resign, that they had no other option. They could also claim unfair dismissal if you do actually dismiss them and they feel that the process wasn't managed fairly, or that your outcome to dismiss wasn't a reasonable one and that you actually had another option. What's really helpful here is having a solid audit trail and an explanation as to why the business felt that this course of action was the right one to take. And realistically, it should be the only option. Having that audit trail and that explanation can really help to defend these type of claims at court. If there's a trade union involved, I would also consider whether they will look to take industrial action, such as striking. It could be that they advise people to work to rule, like Katie mentioned before, or it could be that your union start to refuse to engage on other activities that you would normally need their support on. So you probably want to think about engaging with them early in the process as well to try and help them come along that journey with you.
Absolutely, Emily. And there are also other risks as well that you can't necessarily put a figure on straight away. So you could have increased absences during and after the consultations, which can have a large impact on the business. You can also potentially lose valued employees, either because they choose not to engage in the offer of a new contract or because they resign soon after as they're unhappy with the changes. It can have a real impact on morale and employee engagement generally, and you could find that you don't see the same levels of performance as before, and that you might have behavioural issues as well as employees become unhappy and a little disheartened about it. You have to consider all of this, not just in the short term, but also thinking about the potentially long-lasting damage to trust and those working relationships that might suffer from such a decision. It might not only be the impacted colleagues as well, but other colleagues see what's going on in the business and might have their own feelings about it as well.
Wow. I mean, there is a lot to consider there, and presumably there's some kind of case law and some employment tribunal cases that can, show how these cases can go.
Absolutely, and I think the biggest one in recent memory is involving Tesco, with the decision being delivered back on the 12th of September 24. So this was a case brought by USDOR, the Shop Workers Union, So in 2007, Tesco closed some of its distribution centres and offered the workers a retained pay to incentivise them to relocate to other sites substantial distances away. They all moved houses and some took out mortgages based on Tesco's arrangement to retain their pay permanently. Now that's the key phrase there. So Tesco stated that this meant that, and this is in writing, this was protected or guaranteed for life, and they further clarified which remains for as long as you are employed by Tesco in your current role. And they also wrote, it cannot be negotiated away by Tesco, Usdaw or Usdaw shop stewards in future negotiations. In 2021, Tesco then sought to negotiate away that entitlement. So they offered an enhanced payment as a compensation for it, but the employees rejected that. Tesco then announced that they would dismiss the colleagues and offer re-engagement without that retained pay. The affected employees issued proceedings in the High Court, which held that there was an implied term that prevented Tesco from exercising the right to terminate for the purpose of removing or diminishing the employee's right to that retained pay. They were granted an injunction restraining Tesco from dismissing the employees on this basis. There was then an appeal by Tesco, which was upheld in the Court of Appeal, and Usdaw then appealed again to the Supreme Court. So the Supreme Court unanimously upheld Usdaw's appeal. Lord Burrows and Lady Simler, with whom Lord Lloyd Jones agreed, held that as a matter of construction, the express retained pay terms were permanent, and to hold the entitlement could be terminated merely by dismissing on notice, which is what Tesco had suggested, would deprive it of any real meaning. Also, the qualification that retained pay can only be changed by mutual consent meant that permanent, as a phrase, had to carry a meaning other than cannot be removed by collective bargaining. There was therefore a tension between the retained pay clause and Tesco's right to dismiss on notice. So the court implied a term that the right to dismiss on notice cannot be exercised for the purpose of depriving the claimants of their right to that permanent retained pay. They also said that it was inconceivable that the parties had agreed that Tesco retained that unilateral right to end the retained pay entitlement by providing notice, or that the employees had agreed to place themselves at greater risk of dismissal as a result. To do otherwise would render the promise of permanence absolutely meaningless. So it's a well-established fact that an employer's right to dismiss an employee is constrained, where doing so would frustrate the operation of a contractual benefit. But as far as precedent is concerned, there's a wider principle to be taken from this case that fire and rehire is not possible there isn't a wider principle to be taken that fire and hire isn't possible where it affects an employee's pay. The Supreme Court was clear that it's not a case involving the ordinary work wage bargain, and that what distinguishes the retained pay clause in this case is the additional working about its permanent nature. So had that wording not been included, the outcome would likely have been quite different. So despite the political context of fire and rehire, this case was ultimately decided on those orthodox principles of contract law, which practitioners will be familiar with. And just to recap, they are that express terms will be read in a manner that gives effect to both of them. Where necessary, terms will be implied to ensure harmony. And thirdly, that courts are not there to relieve the parties of what they later decide to be a bad bargain.
Thanks for explaining that, Katie. It was a very big case and a very interesting case, and it really did bring to light what the rules should be around when fire and rehire is appropriate and when it isn't, and what is it that businesses are trying to accomplish by utilising that fire and rehire. You mentioned kind of the political landscape at the moment regarding this. This was such a landmark case that it really brought up the conversation again, and we're now expecting changes to the rules around fire and rehire processes in the Employment Rights Bill, which is being scheduled for implementation in October 2026 and beyond. The bill is going to look at fire and rehire and what we're thinking it's going to do at this moment in time. We're just waiting it to get past the final sign off, and we think it's going to significantly restrict the use of fire and rehire by making it automatically unfair to dismiss an employee to then re-engage them on new terms, or to dismiss a colleague who is refusing to accept a variation to their contract. So the only times that businesses will be permitted to use what we know now as fire and rehire, is if they can demonstrate that not making the changes would place them in severe financial difficulty and that the changes would have mitigated that. This is going to make it a lot harder for businesses to use this fire and rehire process. Realistically, they're going to have to be able to demonstrate that they were in a situation where they could lose the business, where they could go into administration and be bankrupt if they did not initiate these changes. That's the only way it's going to be able to be justified now to use fire and rehire to get a change of contract through. They must also be able to demonstrate that the changes were the only way to mitigate the risk and that there were no other options that could have saved the business. So again, it's not just that it's a solution, it has to be the only solution. Even then, once the business is able to prove that they have met this financial exception test, they would then still have to ensure that the dismissal in and of itself was fair in all the ways that we've already spoken about in terms of that meaningful consultation and that fair process. More broadly, the bill will also find that a dismissal is going to be automatically unfair if the business does it with the intention to then refill the role with agency or contractors who would be carrying out substantially the same work. So it's tried to close off a loophole there that just because you can't hire that same person back, it doesn't mean you can dismiss them and then replace them with that agency or contractor. In practice, this means that if businesses are seeking to make unpopular changes to contracts, they're going to have to think of other ways to encourage employees to agree to them. What I would say is that businesses need to start preparing themselves now, and there are some steps that you can take to support yourself, or that businesses can take to support themselves moving forward. I would say that firstly, you want to consider any wording within contracts, because this is now going to be a lot more important moving forward. So checking what is included in the contract, what is specified in there, because anything that isn't included in the contract wouldn't necessarily be covered by the bill's protection necessarily. And whether you have any flexibility clauses that would allow a business to change the contract without the employee's agreement. Flexibility clauses are things that exist now, but we would also say that you would need to take legal advice regarding flexibility clauses, because to be clear, it is not a get out of jail free card that would allow you to make any changes that you want, but it could well support you in terms of what is and what isn't going to be covered by the Employment Rights Bill.
Thank you, Emily. And I think the other thing businesses can consider as well is how they can sweeten the deal when it comes to making the changes. So this is where it leans into the more ethical side of the process as well. And as we said earlier, if you felt that signing a binding legal contract and then someone who tried to change it to get you to agree to less favourable terms, even if it's for a good reason, you probably aren't going to feel very happy about that. So businesses can also consider what favourable terms they could offer to almost balance the scales when it comes to those changes. We've mentioned earlier about introducing changes gradually to try and lessen the blow, as it were, but businesses could also consider a kind of a trade-off. As an example, if we need to change working hours, could it also offer an additional day of annual leave each year? If we need to change working locations, can we offer other benefits such as healthcare payments? This could help businesses get through much needed changes with the agreement of colleagues, rather than having to try and force it through, which could lead to those difficulties that we've discussed.
Now, again, thank you for explaining that. And there are a number of changes potentially coming with the Employment Rights Bill. So we're going to be sure to keep you all up to date as the bill works its way through Parliament. But what I want to do now is move on to zero-hour contracts, as we mentioned in the content section at the start. Katie, do you want to talk us through what they are and what the benefits for businesses using these are?
Yeah, absolutely. Thank you very much. So zero-hour contracts are where neither the employer nor the employee has any obligation to provide work or work any minimum number of hours, unless specific hours are agreed on a week-by-week basis. So the original purpose of those zero-hour contracts were for those who work as required to supplement and not replace core staff of the business. Since about 2012, the number of workers on zero-hour contracts have increased significantly, with almost 1.2 million workers in the UK on those contracts at the moment, and the numbers are seeming to continue to increase. Large employers with hundreds of thousands of zero-hour staff between them include the likes of Burger King, Domino's, Frasers Group, and the contracts are still routinely widely used in social care, hospitality, and logistics industries. And of course, for some workers, for example, students who work part-time and work when they can, the flexibility is really appreciated. And for employers, that can also be really useful in managing resource and seasonal and other kinds of fluctuations in the requirement they have for workers. Using zero-hour staff can also reduce the number of redundancies or layoff needed for those permanent workers when fluctuations occur. Tensions have grown, however, with some workers whose main income comes from such work, finding it really difficult to have any income stability. And survey results do show that there is a desire for many workers to see more safeguards generally for zero-hour workers. So as successive governments have been working to curb the excessive use of these contracts for several years now, as a result of that, some companies, so McDonald's, for example, offer workers an option of a guaranteed hours contract as an alternative, and they do that already. So employers have been anticipating legislative change for a little while now.
Okay, so where do the difficulties start to come in with zero-hour contracts?
So yeah, whilst they can be popular from a business perspective because it does give that level of flexibility, from an employee and also from a reputational perspective, they definitely come with some ethical questions, and Katie has touched on a couple of those already. I myself have been on a zero-hour contract before. I worked as a waitress when I first came straight out of university. For me as an employee, my main concern was the lack of guaranteed hours. You know, I was trying to save up for a deposit. But, you know, if you've got other workers who are, you know, trying to support themselves, or if they have, you know, family that depends on them and they've got daily living expenses and a mortgage and regular bill payments, for example, it can be really difficult on this type of contract, not knowing what amount of money is coming in each month, if any. And not only is that difficult from a financial perspective, but it can really take a toll mentally as well if the employee is dependent on that income, and then, you know, they don't know whether those hours are going to suddenly dramatically reduce or even just never materialize. From a business perspective, if a colleague is on a zero-hour contract, they don't have any obligation to accept those hours that the business offers. So whilst those contracts do give businesses more flexibility, if there's a downturn in work, for example, it could then come at a detriment that they can't fully expect colleagues to pick all the hours back up again when required, or if there's suddenly a large fluctuation in needing those people to come in. So it works both ways. The other thing that businesses cannot enforce is an inclusivity clause on zero-hour contracts. So what that means is they can't stop an employee for working for another business, and you can't dismiss them or treat them detrimentally for it as well. Again, this is to account for that ethical dilemma that employees on zero-hour contracts are not guaranteed a set income, and therefore they may need or they may want to look at having multiple zero-hour contracts to reach the income that they need. And zero-hour contracts are another piece of employment practice that is going to be changed as part of the Employment Right Bill as well.
And what are we expecting that part of the bill to be?
So I'll pick that up. Under the plan changes in the ER bill, zero-hour workers will get, and there's a list here, they'll get a right to guaranteed hours. So qualifying workers will be offered a guaranteed hours contract based on their average work over a reference period, and that's expected to be 12 weeks. Secondly, the right to reasonable shift notice. So employers will be required to give workers reasonable notice for the shifts that they're working. Thirdly, compensation for cancellations. This is a new one. So workers will be entitled to payment if their shifts are cancelled or cut short with very little notice. Fourthly, extension to agency workers as well. So those protections will extend to agency workers to prevent businesses from avoiding the new regime by engaging through an agency. It is recognised that some workers need and value the flexibility that the zero-hour contracts can provide, as we said above, and there's no wish to take away that flexibility altogether. So those who are offered guaranteed hours will be able to turn them down and retain the existing current contract arrangement if they so wish to. It's also recognised that there are cases where unions and employers working together might want to agree more tailored conditions than the provisions currently allow, and which would benefit both those workers and the employers in that sector, given the unique context that they may work in. The Employment Rights Bill includes provisions which will allow collective agreements between trade unions and employers to opt out of those zero-hour contract measures. The bill is still making its way through that legislative process, as Emily touched on, and we'll continue to watch the space for those exact details.
And again, there is so much coming as part of that bill. We're going to be sure to continue recapping it and keeping you informed of what you need to be looking at in the run-up. Now, have there been any employment tribunals regarding zero-hour contracts at all?
Yeah, thank you. I'll grab that one. So there will have been plenty, I'm sure. But I'll talk about a couple of key things that I can think of, both in favour of the employer and in favour of the employee. So one employment tribunal was Kemp versus Norwich and Central Norfolk Mental Health Resources. So the crux of this was whether colleagues employed on zero-hour contracts are entitled to full employment rights. Generally, they are. So colleagues on zero-hour contracts should not be treated less favourably. They, should go through the same process and policies, and they need to be granted their statutory rights, including entitlement to holidays and national minimum wage and things like that. But in this case, the claimant, Mrs. Kemp, claimed that she was owed wages despite having not attended one shift in the whole of their employment, following a dispute with the employer. So they'd started, had a disagreement, and then Mrs. Kemp had never actually done a shift. The tribunal found in favour of the employer, noting that the contract itself and the subsequent documentation that Mrs. Kemp received clearly stipulated that it was a zero-hour contract, meaning that the company had no obligation to give Mrs. Kemp any hours whatsoever. And again, this demonstrates the importance of businesses being transparent and clear in their contracts and in any audit trails, because it could be heavily relied upon in a tribunal situation, which it was here, because the court was satisfied that Mrs. Kemp was aware that there was no obligation for hours to be given. And then, whilst not an employment tribunal, just picking on something Katie said earlier, another piece of interesting news was the BBC investigation in 2023 into zero-hour contracts, significantly at McDonald's, and the subsequent fallout that came from that. So Katie's already mentioned that McDonald's switched from offering just the zero-hour contracts to also offering contracts with those guaranteed minimum hours, and that came as part of this. As of January of this year, though, so January 2025, 89% of McDonald's workers in the UK are still on those zero-hour contracts, despite McDonald's also offering the minimum hour contracts as well with the guaranteed hours. So it'll be interesting to see how the Employment Rights Bill affects those kind of percentages as well moving forward. What was noted was that a link has been drawn between the number of zero-hour contracts used and the behaviours that are seen amongst the staff at those businesses, most notably sexual harassment. Again, if we're thinking back about that ethical side of zero-hour contracts, it's been suggested that due to the level of insecurity that people may feel on a zero-hour contract, because they know that hours could potentially be taken off them at a moment's notice, it means that employees are reluctant to raise any potential concerns that they have about their working environment, allowing for behaviours such as harassment, such as discrimination, to go unchallenged because the employees are worried about being punished for bringing those things to light. This will not be a problem that only McDonald's would face. I'm sure that every business that uses zero-hour contracts may well see this trend, because you can imagine how people may fear that they will be punished by having no hours given to them if they were to stir the pot, as it were, even though these complaints can be absolutely valid and they should be dealt with appropriately. So I think for this, you do have to then start questioning whether a zero-hour contract by its very nature causes a real power imbalance between employer and employee that is quite difficult to overcome. And I think that's what the Employment Rights Bill is trying to address.
Absolutely, Emily, and that's why it's so important for businesses to think through why they're using zero-hour contracts. And to recap, ACAS recommends using them where there is a genuine demand for work changes week to week, or there are surges in demand, or if the colleagues are used as ad hoc workers to cover sickness absence, for example. If colleagues, though, are realistically working a set number of hours each week, businesses should start questioning whether they actually should be on zero-hour contracts, and does that reflect the arrangements that they have. So 8 or 16-hour contracts with the provision for additional hours being offered is a good option. And as the Employment Rights Bill gets closer to launching as well, it's even more important that businesses start thinking ahead about these things.
And that is some great advice and some really interesting examples. So thank you for sharing your thoughts with us today. I hope you noted as well that a couple of the slides were the wrong way around there. So I must apologise for that one. We were talking about McDonald's when looking at the Norwich case. But again, it's going to be in the slides for you to recap later, Rob. On the subject of questions and maybe questioning the organisation of that slide there, we did have a few interesting questions that have come in for you guys, if that's okay. We've still got time to cover them. The one that I wanted to pick out first here was, when is the full detail of the Employment Rights Bill going to be available? Now, Emily, could you answer that one?
I wish I could. At the minute, it's a little bit of how long is a piece of string, unfortunately. So there's still numerous bits of the bill that need to go through further government consultation. So they're kind of, it's getting battered backwards and forwards between the different parts of Parliament at the moment, whilst they try to agree what each section of the bill should definitely look like. So for example, one of the additional parts of the bill is whether they are going to change employment tribunal to be a day one right. So currently for unfair dismissal claims you need to have 2 years service. They're considering changing that to be a day one right. One part of Parliament had suggested it should be 6 months, one still suggesting day one. So it's kind of bouncing backwards and forwards at the minute. So as you can imagine, that rule and many of the others within the Employment Rights Bill have massive impacts on working practices, impacts on businesses, for so many different reasons. So it's definitely something that businesses and HR professionals need to keep an eye on to see whether it does go through as we're expecting it to go through, or whether there will be some small amendments and different accommodations before it's finally published. So currently the bill has been through both the House of Commons and the House of Lords, and it's now been bounced back again, and we're just considering those amendments. So we're at the editing phase. Once they've decided and agreed on what that bill should look like, it will then go for royal assent. And once the royal assent has been passed, we will then be in a much better position to confirm exactly what the definitive changes is going to be. At the minute, there's some things that will come in immediately once royal assent's gone through, and then we're expecting changes to come in April 2026, October 2026, and then into the early parts of 2027 as well.
Super, brilliant. We've got another one here as well, so it's quite an interesting one. If you bear with me a quick second, my slides have just frozen. I don't know if you guys can see that second question that's come through, but I'm having a bit of a technical difficulty on this side.
Yeah, sure. I can take this one if that's okay.
Yeah.
Oh, brilliant. Yeah, if you can.
And it says, should we stop offering 0-hour contracts in preparation for that new legislation that we've just been talking about? So for now, 0-hour contracts are still a viable source of employment, and indeed we've covered the benefits of using them in your organisations where appropriate. But thinking ahead to what might come in the Employment Rights Bill, you should start considering whether you have any people or roles down as a 0-hour contract when actually the person is working at least a minimum of 8, 10, 16 hours a week, or whatever that might be. And in these situations, you would consider whether or not it would be best to start thinking about moving people onto that minimum hour contracts, as this is the most likely possibility to come out of the Employment Rights Bill. And as we've already discussed, though, you should not be making changes to those contracts without the employees first having a discussion with you about them. It may be that the employee is perfectly happy to remain on the 0-hour contract, as that's what flexibility is good for them. And that's fine under the new law. I'd say keep an eye out for upcoming news from the bill. And again, it's possible that some of the amendments may take place before it's finalised.
Superb, superb. And I'm still a bit frozen on this side, and I know I've highlighted another couple of questions, so I'm wondering if somebody will be able to dive in and read that one out for me, if that's okay.
Yeah, no problem. Let me have a little look. Oh yeah, I can see one there. So offering fewer or no hours to a 0-hour employee 1 week can be a process-free way of dealing with poor attitude or minor misconduct rather than lengthy disciplinary process. Would that not be possible after the changes? Okay, so I think the crux of this is obviously if you have an employee who is underperforming, or maybe they're letting you down at the last minute, or you've got some attitude concerns, one of the easiest ways to deal with it would be not to give them the hours. It might seem like this is a simple solution, but this is one of the reasons that 0-hour contracts are being looked at as a whole. Even now, I wouldn't advise to use the offer or allocation of hours as a method of disciplining an employee or punishing an employee, because there is still that implied term of trust and confidence in any contract of employment, even one for 0 hours. And I'm sure that it will definitely be something to avoid when the amendment comes in. What I would say is, if you're having issues with colleagues on 0-hour contracts, the policies and procedures that you have in the business for conduct, for performance, for sickness, whatever it might be, they are still likely to apply for your 0-hour contract employees just as much as they are for your other full-time or part-time employees, unless their contract says something different. And following those processes and policies, that's what they're there for. That's the safest way to deal with those concerns. Firstly, it's less likely to cause relationship issues, as you will be seen to be following a fair and a transparent process to deal with the situation by the employee, rather than withholding the hours from them, which they may see as more of a personal attack potentially. Secondly, it's also less likely you're going to get in trouble at an employment tribunal claim, because if you followed the correct and reasonable process and you've got all your paperwork to demonstrate that, you're going to be much more on the right side of things. Whereas if you've stopped the hours and you're unable to explain a good reason that you followed a process to do that, you might end up in a little bit of a sticky situation.
Spot on, spot on. And I think I'm still a bit frozen on this one, but there was one more question that I'd highlighted.
Yeah, I think I can see that. I'll read it out and I'll let Katie
You've
answer
got it there. Thank you very much indeed. What a hero.
That's okay. Don't worry. So Katie, we have a group of employees who are on 0-hour contracts and work typically 30 hours a week. Length of service ranges from 6 months to 10 years. How would they be affected by the upcoming changes?
I don't. Sorry, I don't have sight of that, Emily. If you wouldn't mind.
Oh, could you hear me then? Sorry to go.
I'm so sorry.
Oh, no problem. That's fine. I will. I'll pick that one up. No, it's okay. Reading it out, it's hard, isn't it? So yeah, just to repeat. So we have a group of employees who are on 0-hour contracts and work typically 30 hours per week. So it sounds like they're doing a standard amount of hours. So their length of service ranges from 6 months to 10 years. How would they be affected? So I would say if an employee or group of employees have become regular hours workers in all but label, it might be worth recognising that by talking to them about if a minimum hours contract or a salaried contract is more appropriate for them. I think Katie mentioned that a little bit earlier as well. Even now, if there's no longer any required for them to be offered hours and there's no expectation for them to not be available for hours, then it might be that that contract label of 0 hours no longer really reflects the reality of that relationship. Length of time alone being on a contract doesn't determine things, but the longer someone works regular hours for, then the more likely it would be that they would have a successful dispute to the 0 hours label. So for example, you've said there some of them work there for 10 years. If they've been working 30 hours per week for 8 years of that, I think they'd probably have a good leg to stand on to say it's not really a 0 hours contract. In the event of a dispute, a tribunal does have the ability to delve into the reality of the situation and make its own determination as to what the contract terms are, based on the performance of the contract by both parties. So just the label of the contract itself is not going to provide you with the protection that some businesses think it does. So just because it says 0 hours in paper doesn't mean that that's how the tribunal will look at it if realistically it should have been a minimum hours contract, for example. The risk could be that if you stopped offering hours to somebody in this scenario, it could be a dismissal, it could be a breach of contract, there could be lots of things that they then go and start to claim at employment tribunal, because actually, even though it says 0 hours on paper, realistically, it's absolutely not. Therefore, what I would say is that for those employees, if they've been working there for a length of time, if they are doing set hours more often than not, I would strongly consider whether or not you wanted to move them over to a guaranteed minimum hours contract rather than keeping them on the 0 hours contract, just because then it reflects the reality of the situation, which is what the tribunal would look at it like anyway.
Superb, brilliant. Well, Emily, you've been a hero there. You've saved the day by being able to highlight those questions out.
Technology is always.
Spot on. So we hope you found today's session valuable. I know I have. And if we weren't able to cover off the questions, then I can note there's still about 6 or 7 that have come in there. Unfortunately, we haven't got time for those, but we will be in touch with you directly afterwards and follow up with you personally to get you answers to those questions. Emily and Katie, thank you so much for your insight and obviously your guidance today. It's been absolutely wonderful. Barring the technical hitches, that we've had. I think we've soldiered on through that one. Now, don't worry as well. If you'd like our help with anything that we've covered, please feel free to check out any of the topics covered in the Sage HR Advice portal, or alternatively, you're a professional or a premium customer, please do not hesitate to call the advice line, where one of our consultants will happily provide you with any guidance on any of the topics that have been covered today. And just to let you know as well, Sage HR Advice is here to help you navigate and plan your approach to HR. And alongside Sage HR, you can automate and simplify tasks, calculate holiday entitlement, arrange shift scheduling based on the people's contracted hours, and automatically long hours worked. I love that little shift scheduling. I love saying that. Never get bored of it. A couple more things in relation to HR Advice and Sage HR2. Sage HR Advice is here to help you navigate and simplify any changes that I mentioned today, and also include a digital e-learn library with lots of additional resources and toolkits there for you. Alongside this, there's Sage HR, which you can automate and simplify tasks, as I've said, loads of HR tasks, and really customize things to suit your company. We do have webinar recordings of some of the different modules of Sage HR if you're interested in knowing more about them, which you can watch at sage.co.uk/webinars. Please do. I'd highly recommend you getting more information on the products mentioned as well. And I'm going to launch a poll shortly where you can answer yes if you'd like us to contact you, and we will do so after the webinar has ended. Just before I launch that poll though, just to let you know, we'd like you to have your say. So what topics do you want to see next? What would you like to see the experts talk about and have me nod my head to? What interests you? So when this finishes, you'll be sent a survey. Please send us your requests. We read absolutely every single comment, as well as answering absolutely every single question. And we really value your input on it as well. So what you liked, what you didn't like, what we can change moving forward to make the content better for you. So please, please, please submit that feedback now. And the up and coming webinars we have just in front of you here. So as you can see, the dates and times are there, but as well as you can get them on our sage.co.uk/webinars handout as well. Now, as promised, I'm going to quickly open this poll for you to see if you would like to gather some more information on what we've already mentioned. And I'm going to leave it up there for a moment for you now. You should be able to see that on your screen, hopefully. Well, we are blue screen. So it's just a radio button, just to know which product I'd like to hear from. So if you want to, then happy to be contacted. We'll get in touch with you as soon as possible, possibly by the end of the week. But while you're answering that question, just to read out the slide that's in front of you there. And the Sage 50 payroll, we've got attachments on the 23rd of October, and that's at 2 p.m. So that's tomorrow. We've got minimum wage check on the 24th of October at 10 a.m. We've got month end, the 29th of October at 10 a.m. Maternity pay is a very, very good subject that we're covering on the 31st of October at 10 a.m. So Halloween, that will be on a Friday. Our next HR advice webinar is on long-term sickness and ill health capacity, and that's going to be on the 4th of November, that too. Be excited for that one. Very interesting topic, I think. Relevant as well. So just waiting for a few more votes for people who are wanting to see and be contacted by ourselves. I'm going to leave that up just for 20 seconds more. Brilliant, brilliant. Super. Well, thank you very much, guys. Again, thank you to Katie and Emily for your attendance, and thank you guys for your ears and attendance today. If you could complete that survey for us, that would be absolutely wonderful. But hopefully, we'll see you at the next one. Bye for now.
Thank you. Bye.